Welcome everybody to Ask a Pro number 4, to What Not to Patent, Steps for Strategic Intellectual Property, featuring Mary Lou Wakimura from Hamilton Brook Smith Reynolds, and hosted by me, Linda Plano. I am a pitch coach for high-tech entrepreneurs, and I have started this series to bring you practical, useful advice on how to move your startup forward with the most efficient way I can help you come up with. Okay, before we dive in, let me just do a quick couple of thank yous. Of course, the MIT Enterprise Forum of Cambridge is where we have the MentorSmart program, which we launched a couple of years ago. We're about to launch our 5th cohort next week, and each time we're asking the mentees, what are the subjects you would most like to hear about? And so that is part of why we've got intellectual property coming up today. Special thanks, as always, to Katya and Amy in the front office for helping us make all of stuff work. And special thanks especially to Hamilton Brook Smith Reynolds for being a gold sponsor. MIT Enterprise Forum can't function without its sponsors, and you've been a great and long-term sponsor, so we really appreciate that. And just a brief commercial coming up on the 5th of November, Winning with SBIRs, Funding Your Startup Without Dilution. Even though Natalie is in biomedical consulting, this will be across all kinds of technology. So it'll be a great webinar. Hope you can join us. And then we'll do something a little bit different on the 19th of November. These are all Thursdays at noon, by the by. This will be an interview with one of my clients, Gary McNamee, with Outside Interactive, and he has bootstrapped like crazy, often contrary to my advice. So, and he's really making some amazing things happen this year. So join us for that one. And then on the 10th of December, we'll be looking at user interface design for startups. Okay, so here we go back to the main content. Now, you're probably really concerned about your intellectual property, like any entrepreneur would be. Your decision whether or not to patent has a huge impact, right? The wrong decision will cost you a lot of money and or a lot of opportunity. So we are going to talk a lot about the patenting process itself, because most of you probably have intellectual property you would like to get that with, but we're going to start and end up with advice on what not to patent. We're very, very fortunate to have Mary Lou join us today. She is a very down-to-earth and sensible attorney who has been just great to work with. I appreciate that very much. She has a few decades of experience in intellectual property law and has very kindly agreed to be willing to spend 20 to 30 minutes with anybody who would like a free orientation session. So her contact information will be available at the end of this webinar. In the meantime, you can also download her slides from your control panel. During this whole presentation, please, by all means, add your questions inside the control panel, and we will, as time allows, we'll switch over and have you actually be able to talk to her directly. So get your questions answered live. Okay, with all of that, Mary Lou, I am going to turn it over to you and say just thank you very much again, and welcome to Ask a Pro.
Thanks. Thanks very much, Linda. Can you hear okay?
Absolutely.
Great. Okay. So this is Mary Lou, and I'm a principal of Hamilton Brook Smith Reynolds. By way of quick introduction of my firm, we're an IP boutique shop. That means our services are focused on obtaining, defending, enforcing, and licensing clients' rights under patents, trademarks, copyrights, and trade secrets. We have backgrounds that spread across the gamut of science and engineering disciplines. The firm has 2 office locations in Massachusetts, one in the Seaport District of Boston and the other in historic Concord. I'm one of the 38 practitioners of the firm, and my particular technical expertise is in the computer and software related industries. I represent inventors and inventions before the U.S. Patent Office, and that's referred to as patent prosecution. I have served as outside patent counsel for entrepreneurs, startup entities, companies of all sizes, your Fortune 500 corporations as well. My other practice areas include IP due diligence, software copywriting, software licensing, including open source licensing. So today I'm presenting 10 steps to strategic intellectual property, not just patents, and I refer to these 10 steps as my punch list for guiding you through key considerations to more thoughtfully and strategically build that IP portfolio. So just like in real property, real estate, intellectual property is about setting boundaries of what's yours and what is not yours. So the property that we're talking about when we say intellectual property are those elements or features that make your business competitive. So as an initial exercise, write a list of what distinguishes you from the competition. And then look at that list and let's prioritize it by asking a second question. How well can you compete without any one of those distinctions that you wrote on that list? A couple of those distinctions will probably bubble up to the top of the list because you would answer that my business could not operate without that particular element. So then comes the question, what forms of IP protection should you use then for each of those listed distinctions? Which ones not to patent, which ones would do well with patent protection, or some other mixture of IP protection? So at this stage, you would be able to then refer to this punch list for guidance. So let's step through each of these in turn. There are 4 mechanisms for defining or setting those IP boundaries. Patents, trademarks, copyrights, and trade secrets are those 4 mechanisms. So patents protect an invention or discovery and sets that boundary around what's novel and non-obvious and defines an advancement in technology or innovation, your invention. Trademarks protect your business signature. So that's a logo, a domain name, a color scheme, any indicator of you as the source of certain goods or services. So time and source distinguishing use of a mark in commerce defines the boundary for trademarks. The longer you use the mark uncontested, the greater the strength of the mark. Copyrights protect original authored works. That is the author's expression in a fixed medium. So that version that's in the fixed medium sets the boundaries or limits of what the copyright protection can hold. Trade secrets protect confidential data, techniques, or information that give you an edge over your competitors. And trade secrets protect against misappropriation. So the confidentiality measures that are taken, that's what's drawing the boundaries here. So take a look at the left half side of that circle, the patents and trademarks side. Those are mutually exclusive mechanisms. Trade secrets, for example, last as long as the secret is maintained. Contrast that to patents, which is a government-awarded 20-year term in exchange for disclosing everything about your invention, how to make it, how to use it. So another contrast between patents and trade secrets comes out. Patents will protect against reverse engineering. Trade secrets do not. So if a competitor reverse engineers a trade secret, the secret treatment is lost and therefore trade secret protection ceases. On the other hand, if a competitor reverse engineers a patented invention, that competitor is liable as an infringer under patent rights. So one item of what not to patent are technical know-how that is not easily reverse engineerable. Those could be kept secret and much more protectable as a trade secret than as a patent. So that's, I'll say, the tip number 1 of what not to patent. you'll find there's,
Uh,
go ahead, Linda.
Sorry about that. Yes, do you have any examples of a trade secret that's really worked out?
Sure, a couple come to mind. The um, recipe for Coca-Cola, that specific flavoring. It could have been described as a chemical type of patent, but the choice business decision was to, we think we can formulate it, even though it's out there in the public, it's exposed to lots of people who are chemists and could try to reverse engineer it. They came close maybe with Dr. Pepper or other RC Cola, but the Coca-Cola flavoring has lasted much longer than any patent that would have granted on that formulation.
So that's been like 83 or 85 years, right?
Yeah, yes,
Do you know how
yes.
they've been able to protect it in such a huge corporation with so much competition?
Yes, they are very good at need-to-know basis type of treatment. So inside um, their plant, the actual formulation or recipe is not just locked up, but people who have access to that level of information are very few, and you have to um, sign all sorts of waivers. Any visitors are only allowed in certain areas of their plant, and that's usually when you see a sign-in sheet, or certain corporations make sure they understand who you're visiting, that you're escorted at all times, and have a proper badging to get through, different levels of um, guarded areas. And if you don't have the proper pass, you're not allowed in.
Great, thanks.
Sure, sure. So there will be times when you're going to mix and match amongst these four different mechanisms, recognizing that trade secrets is mutually exclusive from patents. And in that mix and match of patents, copyright, trademarks, you also need to understand they have very different timescales. And patents is an area that has one of the most demanding investments in time and money. So to give you an example of that, this is a example U.S. patent timeline. From the day that you come up with your invention, the conception, the next steps are to have an invention disclosure meeting, or at least collect enough of the details of the invention in writing to be able to file a U.S. patent application. Once you file that U.S. patent application, a few pieces of U.S. law and other patent laws around the globe come into play. And one of those is within 1 year of that first filing will be a decision time to file counterpart applications in foreign countries. About 1.5 years after that first application filing, most governments do publish the filed patent application, so the U.S. Patent Office will publish your U.S. patent application. And then about by year 2, you'll start examination. There's certain um, science art groups at the Patent Office that are very backlogged, software being one of them. So we're very lucky if we see an examiner at year 3 for the first time. And that examination process will spread across 2-3 years. So you're about 5 years into the whole process before you really are seeing light at the end of the tunnel as far as a potential for grant of the patent. Once you have allowance in your patent application, the next couple of steps flow towards a payment of an issue fee to have the government grant the patent. And there's some post-grant activity that's available as well. In order to maintain a granted patent, you do have to pay maintenance fees to the U.S. Patent Office about every 3.5 years after grant. So this timeline from start to finish is about 7 years. It can be quicker in certain art areas, science areas, and it can be a lot longer in other art areas. So over that course of 7 years plus, you're paying about $40,000, maybe up to $50,000 and then your maintenance fees beyond that to keep this as a active granted patent.
Well, ouch.
So bottom line, yeah, patents are not inexpensive and they're not a quick solution. So that's your tip number 2 of what not to patent. If you're in a hurry, well, is the 7-year time lag going to get you what you need in the short run?
Well,
There is
not only that, but you
go
have
ahead.
to reduce it to practice before you can hope to get it granted, right? And you have to publish all of that after 1.5 years, and then it's years later before you get it granted. So that decision between trade secret and patent is the real killer one. So
Yeah.
so it basically comes down to, is it more important to have the patent so that with respect to an acquisition or licensing kind of a thing, I would think. Um,
Yeah.
and I guess the other question I had for right now is, how do you decide what countries to file in if you're not, if you want to go outside of the U.S.?
Good question. So think of where your most overt activities are. Where's your largest sales market? Is that U.S.? Is it Canada? Is it many other major countries? So write those country names on a list, prioritized higher than other countries. Your other, besides sales and marketing activities, use, just that type of invention or innovation. Where is the largest use market in dense populations or not third world countries, more of your major countries? So again, certain country names are going to bubble up to the top of that list. Lastly, think of where your business partnering activities are. Manufacturing, distribution, those are other hands that are going to be in contact with your invention, and you probably want to be covered in those countries.
And obviously, the big question I often get from my clients is, I can't go up against, I don't know, Microsoft or BP or whatever. I don't have the deep pockets to do that. What's the point?
Right, right. So patents are usually to your Microsofts and your big powerhouses. Patents are looked at as an asset, a trading chip. So that's the other tug in that decision of, oh, well, I thought I was deciding to use a trade secret level of protection, not a patent. But if you do spend the money and have patent pending and mark your items as patent pending and get to be a little bit known in your market and you're making some inroads, that patent application, even before a granted patent, is a tradable, negotiable asset with these larger players. So you're giving them a lot of lead time with all that R&D behind the patent, the written disclosure in the patent. And even if you're a little guy, you do bring to the table a valuable asset in a patent or patent application that the IBMs, Microsoft, Googles of the world have looked at. And it may not be necessarily a complete acquisition merger with them. They may just want that particular crown jewels out of your IP portfolio. So there are those reasons saying that's why you do want to patent your I'll say largest crown jewels of your business.
Actually, I meant a little bit more like, that's great and true, but what about if Microsoft, and I don't mean to slander any one company here, I'm just using them as an example, but what if they decide they just want to go ahead and use the technology, even though I have a patent on it? I don't have the deep pockets to pay for years-long kinds of litigation. So is it more or less trying to just make it cheaper and easier for them to license it than to steal it? What's the thought process on the big company side?
Yeah, this is where I say the power of the media, and that in the electronic digital age, things can go viral very cheaply and easily by one or two people who are not big players at all. Um, and certainly the larger corporations don't want to be known as the so-called thieves, where you have good documentation showing, hey, I was the original inventor of this. And then the published by our government published patent application shows the date, my name, what the invention is, and how it works. And here, Microsoft has pretty much, or company ABC has taken off with that, and I'm left to, write my white papers and nice little YouTube videos saying that this has uh, taken a turn for the worse, because they're not listening to wanting to license from me, or even playing fair as far as using this bargaining chip as an asset that
Oh, that's
I'm willing to license, that I'm willing to sell.
wow. I'm glad to hear that. Actually, I hadn't realized social media had been used in that way. I'm just going to take a moment here and remind everybody, I can ask questions all day, but they're not your questions. So take a moment out there and enter a few questions here, and or put your hands up, and we'll take questions as you go along. Thank you so much, Mary Lou. And I hope it's okay
Sure.
that I keep interrupting you here.
Yeah, no, these are perfect. I think they fit right in. So we'll step along our punch list. Item number 2, the lesson is, do keep good records. You can't document enough, especially the very beginnings of an invention. The internal invention disclosure forms are a nice tool for documenting that. Other company records that you should be documenting are a first use of your mark in commerce. That will help when you're about to make a trademark application. Date of first publication on copyrightable items, your web pages, your white papers, uh, other users manuals, other written materials. That first publication date plays an active role in copyright protection. First offer for sale or demonstration or other public disclosure of an invention is also an important date to have a record of. And certainly some of your marketing and sales activities will go a long ways in corroborating some of these dates. So that's a very initial step as you're conceiving and coming up with your inventions or trade secrets. Keep good company records there. Punch list item number 3, you do want to establish ownership as early on as possible. A lot of times your employment agreements are going to have clauses that give, I'll say, advance general ownership back to the company for copyrights, patents, any know-how, technical steps that could be trade secrets. Keep those all in the company name. Very specific per patent application assignments, inventor assignments are a usual that's made, and your employment agreement would hopefully read that a person being employed is agreeing that they will sign these assignment documents. Another area, your invention disclosure forms that we had on the previous slide is a good place to also have some of the inventor assignment language, so that as the inventors are filling out invention disclosure forms, they are assigning their rights to the company for what they've invented. There's such thing as joint ownership. Sometimes it's a collaborative invention, and it's a business partnering or other group that collaborated with some of the inventors being under your employment. So from upfront collaboration type of agreements, make sure it's clear where the IP is to be assigned to and who ultimately will be the owner of that IP. Trademarks go, as far as ownership, go along with the goodwill of the company. So again, it's that visibility, use in commerce, and over time using the mark to indicate your goods and services form the ownership rights there. In copyrights, there's this notion made for hire, which in theory, the original author is who owns the copyright first, but if it's in an employment arrangement situation, the employee author does have their rights in the copyrighted material owned by the company under as long as the work that was made was done through company time as part of a company requested task. It's part of your job. So, and that's why we phrase it as a work made for hire. The ownership would lie with the company.
Actually,
item number 4.
Mary
Yeah.
Lou, sorry. Yes, if I could just ask. So one thing that comes up constantly, for instance, in the Mentor Smart program, and even in my own line of work when I'm coaching I've coached almost 600 high-tech entrepreneurs on their pitches, and of course, many of them would like me to sign a non-disclosure agreement, which makes my life I can't do it, right? Obviously. So can you give any advice about when is how to work with somebody without a non-disclosure agreement, because they have to go and talk to the venture capitalists or other investors as well without non-disclosure agreements, at least for the initial meetings. So do you have any advice?
Sure. So once you've asked for non-disclosure and been denied that, then there's a mutual understanding of that what you're going to disclose is going to be only a limited amount. And that limited amount that you feel comfortable disclosing should have, I'll say, supporting documentation that leads back to proving you were the initial owner and inventor of that. So oftentimes that's where I say, well, then file a provisional patent application.
Mm-hmm.
Those do not get published, and it marks some boundaries of what you had in hand as of X date, and it was the next day that you met with the VCs or whoever with no disclosure agreement in place. That will help you in the argument of who knew what when, and was there some sort of stealing going on or trade of information that went beyond what your limited confines that you had a gentleman's agreement about. And a lot of times I'll say if it was a larger corporation that you were trying to approach, they have a huge R&D program going on, and it's the one individual speaking to you is unable to humanly know at what stage all of the R&D is at that moment of your meeting with them, and they're trying to protect themselves as well. So to be able to say that did they take some of your information and went off and developed that, at least in their books, date-wise, does that predate your provisional filed application or any of your other documentation that supports who had ownership of what pieces at what time? So that's, if you can set up some of that supporting documentation ahead of one of those meetings that is not under a disclosure agreement, non-disclosure, then you'll be in a better position, and as well as the other party. And I think the two of you will agree that this, because it's under without any confidential arrangement, that it's going to be a limited amount of information passed at that point in order to at least decide, is there any chance of further discussions, and in those further discussions be able to necessarily then have a non-disclosure agreement in place.
So it all comes down to good documentation. And I have to admit that way back when I was an actual scientist and an actual startup company, keeping records was not my strong suit. Let's just put it that way. I wound up on a couple of patents, but really my notebooks were not great. Do you have any advice, or have you run across anyone who has a particularly good process or system for making sure the documentation is done right amongst the people in your startup?
And that's a very good question. I don't have an example of, I have a hypothetical example of what one should aspire to.
Okay.
And that would be, it sounds old-fashioned. There's such things as engineering logbooks, but nowadays so much is done in software, or at least trails of emails and other documentation that's in electronic format. So as long as you've got some kind of archiving system on your server, that date timestamps all of this information very easily and readily. And that makes for one way of record keeping. Another area, yeah, like you said, if
that's what
you're,
I was supposed to be doing, right. So I guess
yeah,
it's more you have to kind of indoctrinate. Somebody has to be responsible for holding the developers, the researchers accountable for getting it done. So somebody's got to be
yeah,
looking at those records on some kind of a regular basis. I don't know, on a monthly basis or something.
yeah, yeah, certainly a monthly basis would be a good benchmark. And you're right, it's a whole team effort, because if the person at the bench doing the bench work has got their hands busy with test tubes and testing, they're not really wanting to stop and document to the hilt. So the next, yes, so the next level is, if that up the hierarchy, a supervisor, a manager should also be diligent about keeping some records, making a certain frequency of touching base with each of the other players on the floor, as far as researchers and scientists, seeing what stage they're at, what next level of testing are they doing. And at, at least if the bench worker doesn't have time to document, then the supervisor has some sort of list and can chart that quarterly, monthly, whatever the frequency is. So that's a second layer of documentation that would be helpful. It's witnessed then by an independent, a separate person from the inventor, and is part of the, I'll say, company records.
And
So
it's
that
actually,
invention,
sorry, it's actually an extra
go ahead.
cost associated with patents that you need to kind of budget into your company's overhead, I
Yes,
guess.
yes,
Haven't thought
that's
of it
right.
that way before.
And so sometimes the invention disclosure forms, that handy tool that I said, can be used even at that stage, and have certain portions of that form. If it's not going to be filled out by the inventor, then at least the manager, supervisor can be using that to document, okay, on such and such a date, we still were not ready for alpha testing. Proof of concept, possibly, just enough to have that paper trail. And again, it doesn't have to be hard copy paper. It could be in their laptop and then archived, so that eventually you do have a date, timestamp, a witness, and some of the context of what was going on, enough of the words, so that there's a trail, the supporting documentation to say, yes, this entrepreneur at company A had this earlier than a competitor company, and what came out as far as a published application or in the public news. At least your records can help support the truth.
And if you're not willing to do that, that's another thing not to patent.
Right, right.
Okay.
And so that's the choice. Great. Um, Next is the timing of when to file a patent application or register your trademark or copyright. And as far as a must timing in patents, each country has their respective laws setting the statute of limitations or bar dates. In the U.S., public disclosure, meaning a white paper, demo, advertisement, any kind of activity that's available to the public that gives information about your invention, that kind of activity will start a one-year clock to tick. And within that 1 year, you need to file a patent application or forego the patent protection. So foreign countries, many foreign countries don't necessarily have that 1 year kind of clock grace period. And if you're trying to think down the road where the counterpart foreign patent applications could be filed, you really need to think of that early on before any of your public disclosure kind of activities, so that you understand which of your foreign countries have a first file rule before disclosure. Trademarks, it's you do have a choice between intent to use type of registration process or the actual use of a mark. The intent to use trademark application is kind of a placeholder that says you have an intention to use this mark. You've not yet used it to be able to supply samples of how in commerce you're using the mark. But once you do start to use it, then this actual use affidavits and other components come into play with towards registering that trademark. And as I said before, the actual use in commerce, even without having registered the mark, does gain you common law rights. So there's not as hard and fast statute of limitation in trademarks as there is in patents. In copyrights, the actual set of rights exist upon fixing that authored expression in a medium. So the rights begin very readily without you having to go through a registration process. The copyright certificate you will need in hand when you file suit for copyright infringement. And there is a fast-track way to apply for copyright registration if you know that you're about to file infringement lawsuit. It's an online registration process, maybe 2 web pages long, and there's a particular section in there where you would be able to fast track it because you're about to file suit against an infringer. Other business considerations will drive this question of when must you file. So if you have certain funding and grants or sponsors that require a particular timing of file a provisional application within the first 6 to 9 months, and that you follow up by contractual arrangement, you're agreeing with your sponsors and to follow up the filing with a first non-provisional application full filing by a certain benchmark. So those are other timing requirements that you need to fold into with the statute of limitations types of timing requirements. Another part of when to think of all of these IP activities is during your R&D cycle, there's some key spots to harvest your IP. And it will, if you build it into the habits, like Linda's question was saying, you know, if the bench scientist is too busy to, then up the hierarchy, the manager, the supervisor can follow this type of timeline, that at conception, the brainstorm session, at step 0 through the first 3 months, there's potential for patent applications. So fill out those invention disclosure forms at that time. And they may be design patent application considerations as well as your utility patent applications. And then as the R&D further develops into a few more months, there's potential for other IP. Your trademarks and copyrights, certainly trade secrets, might come into clearer focus then, because you're saying it's taking a long time for us to actually develop this. So it's proving that this will be a very difficult reverse engineer kind of technique, and that might rise to the level of saying, okay, so now we're in that land of patents versus trade secrets and the trade-offs, the pluses and minuses of each of those. And then probably a year into your R&D, you're doing some market testing. Where's the sweet spot? That might produce, fall right into production and produce more patent applications and certainly more trademarks. And then upon product release, there's all the literature that goes along with that and more of your web pages, lots of copyright type of items will come out of that. So through the R&D cycle, you can fold in your IP harvesting activities. Moving on, we went through why and the what and the when, and this is the where that we did touch upon earlier, where to obtain the IP rights. And as I said earlier, you think of your heavy use and sales markets, your manufacturing, where are your competitors' markets. Those are the countries, the locations that you should write a short list of. That's where you would want to aim your IP rights. Trademarks, copyrights are international by a Berne Convention that the U.S. as well as all the major countries are part of. Patents, you do have to think of country by country. So in the global patent arena, there is an international patent application filing that can serve as a single filing to hold your place across many of the major countries, over 140, close to 150 countries with that single filing. What that does as a placeholder is it'll give you a buffer about a year and a half long before you have heavy-duty additional costs. And that's what I call the second stage of a PCT international patent application, is where you do need to proceed with individual country steps, and that's where the costs will come into play. So, but at least you've bought yourself some time. In that time, you will have gotten smarter about where's the market. Do you truly need all of Europe, or is just Canada and the U.S. going to fulfill most of your need for patent protection? The acronym PCT stands for Patent Cooperation Treaty, and it does cover, I'll say, the regions and countries that are most active for patentees. And that second stage is when you'll need per country to abide by their local language, and so translations, a lot of the logistics start coming into play, and that's where the costs come in.
So we have a couple of questions from the audience. Lynx, I'm going to unmute you so that you can ask your question, assuming you have a mic. Hi, Lynx.
Hi. Mary Lou, I appreciate your time. I have a couple questions about, not really about patents, but otherwise. Is it important to get trademark registrations or copyright material in countries where you're having something manufactured outside the U.S.?
Yes, for the trademarks in those manufactured countries, that tends to be where there's more opportunity for pirating of your goods, and so at least a trademark will secure the source, identify you as the source of those goods and services. Copyrights, not as much so for the manufacturing site, but it's a pretty easy use of the copyright marking. You are allowed to do from day one. You don't have to go through the registration process until you are about to file a lawsuit to chase an infringer. So at least the copyright symbol with the your company name and the year of that copyrighted product can happen from day one.
Can I ask a follow-up question? Do I need an
Sure.
international attorney? Do I need somebody specifically to help me with that? Because that's something I have no experience with.
Right. On the you don't need an international attorney. Use I'm assuming that you're U.S. based. Sorry, I just jumped to that assumption. Use a U.S. IP attorney
Okay.
and explain the locations of your activities and if there's off-site manufacturing, and the U.S. Patent Office can serve, Patent and Trademark Office can serve as a uh, location for the U.S. attorney to file for patent protection or trademark registration, and there's certain conventions that we follow in order to spread that initial filing across certain global locations, either by respective treaty, or sometimes there's whole regions that operate under one set of laws. And we coordinate with a local practitioner in those regions. We have a long list of agents and foreign associates that over time we've trusted and dealt with for many patents and trademark cases. The Berne Convention for copyrights says that acting with that copyright notice in the U.S. is good worldwide from day one.
Okay. Thank you.
Okay. Yep, you're welcome.
Great questions.
Good questions. Good. Moving along. So the next 3 steps on the punch list cover ways to help you navigate through the patenting process. So your patent attorney will need your help with describing the invention. And the whole goal behind writing a patent specification, and that's part of a patent application, is that you need a level of detail that enables an ordinary skilled person in the art to make and use to practice, reproduce your invention. So that's the level of detail that we're trying to put into the description of a patent specification. The U.S. has an additional requirement as far as disclosing the best mode that the inventors know for practicing their invention at the time of the patent application. So if the level of details didn't reach all the way to your specific best mode, your patent attorney will ask you for that information as well. There's a strategy behind writing patent specifications, and that's with some foresight to be able to argue against a patent examiner's rejections down the road, and to have some of the support for those arguments already built into the patent specification. So the areas that one are with some foresight looking to argue against are novelty, non-obviousness, and then practical, usable application of the subject matter of your invention. The next step, once you have a patent application and specification drafted, the patent attorney will file that as an application at the U.S. Patent Office. Other parts and documents that go along to the Patent Office eventually are inventor-signed papers, a declaration stating who the true inventors are. There'll be Patent Office fees. There's a duty to disclose information that's material to patentability, and that duty falls not just on the inventors but on the patent attorneys, others that are in control at the company level. So those information disclosure statements that satisfy this duty from the filing of the application through examination up to grant of the patent. There may be several information disclosure statements then filed throughout the time of your patent application process. And if you do not want your patent application to be published, that's another point of strategizing ahead of time. You do have to make that request at the time of filing your patent application. So that can play a part of your business strategy. Maybe you had a tough time deciding between what to go with the patent or not to patent, and the trade secret question came up, and ultimately your funders, lots of other implications said, okay, I do have to file a patent application, but maybe if I request non-publication, I get that first 18 months of more market study, getting my foot out in the market first before the rest of the world would even know that there was a filed patent application. So you can use that as a handy tip when you are filing a patent application that might be very sensitive information and you want to use that 18 months lead time to better position yourself in the market. And then through the after the application is filed and those formalities and fees are filed, the examination process will begin. An examiner is assigned to your case. He conducts his own search to determine novelty, non-obviousness based on other references that he finds around the globe or has particular knowledge in. All the examiners at the Patent Office have at least an initial engineering or life science degree. And the examiner with his research will issue rejections in the form of a written communication called an office action. And the patent attorney and you have the opportunity to respond to that office action. Usually the time frame is a 3-month deadline to respond and come up with your arguments and help the examiner interpret your patent description relative to his findings, the references that he found. And sometimes the references that he found, he's interpreting certain words out of context, and it's up to us to argue to him that that's really taking this out of context, and that what that reference really stands for is something very different than what you're trying to patent. So a couple of rounds like that with the examiner are very normal in a lot of the biotech area as well as software area. To go beyond 2 rounds is very normal. 3 or 4 rounds, and that means many more years and much more patent office fees as well as attorney's fees. So this is where it builds into what we witnessed in one of those early on slides, that it's a long process and an expensive process if you're not properly budgeted for. So set the expectations correctly here.
So can you, hi again, it's me. So can you talk
Yep.
for a moment about how one would set a budget for patents versus copyrights and trademarks?
Yes, yep. So I'll start with trademarks, usually about $800 to $1,000 for an initial trademark search is a good budget. In that search, it'll help point out who else has marks very similar to that, or some of the hurdles that you would possibly face if you were to file an application to register the mark. But once you get past that search pot of budget money, then budget about next $1,000 to $1,500 for the actual trademark application process, and it will depend on how many different classes of goods and services you're trying to cover with that mark. Copyrights, the online registration process, budget maybe $300 to $500. It's very quick, easy. I've been able to do a batch of them, and I usually flat rate those at $500 each. I guess the time-consuming part of that you can help your patent attorney with would be a sample of what gets uploaded to the Copyright Office, a sample of the copyrightable work. In my instance, it's software. So as long as the code, source code or machine language is captured, and if there's any highly sensitive information embedded in that code, we are allowed to scrub that out. So a lot of that upfront work, if that's done by you, and then you have a ready package for the patent attorney to use to upload as the sample for the copyright registration process. It'll go, like I said, you can flat rate it. It'll be inexpensive, a quicker budget use of budget money there. Patents, I think you want to budget anywhere between say $9,000 up to $15,000, thinking of a full patent application filing. Even if the ultimate decision is let's just do a quick provisional application, that should probably cost about $3,000 as long as you've got good documentation and help the patent attorney with that written description to meet those benchmarks. A patent search, if you're still not real sure that you feel you can withstand the arduous examination process, a novelty patentability search I would budget $800 to $1,000 with to help you understand if your sweet spot for patenting really is riddled with higher hurdles, and you now know that the process will be extended. That's a good use of that money, the budget money, before launching into the tens of thousands of dollars for the patenting process. Let's see. So I covered copyrights, trademarks, and patents. Trade secrets, really, the budget there is more on how to control who gets access to what in your company. So it might be an IS exercise of enough passwords to get into certain portions of the computer system. It might be locks on doors if it's a real physical trade secret element. So it depends on your infrastructure to be able to put a dollar budget tag on trade secret steps for protecting the trade secret.
Great. I think we have a follow-up question, Lynx.
Okay.
Hi, this is Lynx again. Back to the copyright process, I kind of have a couple questions. I understand you have to provide a sample, and for software you can take out parts that then someone else wouldn't be able to use. Is that what you meant by scrub some of the code, perhaps?
Right. So the whole program is what's protected by that copyright registration. There may be, and the guidelines from the Copyright Office say that if it's not longer than 20 pages, submit all 20 pages. If it's longer than that, you can choose the first 10 to 15 pages and last 10 to 15 pages. There's all sorts of options of how to be able to capture a sample of that program. The scrub out part is there may be some embedded trade secret algorithms or things in there, and that we by statute are allowed to block off and not submit to the trademark office.
Okay.
I mean, to the
Thank
Copyright
you.
Office, sorry. Yep.
Right.
Yep.
And what if you've published pieces of it in a professional journal or those kinds of things? Does that help or hurt your copyright process?
Oh, so that will be different versions of the content that you're protecting by copyright. So the published, so it helps. So the published paper article version of your content is protected by copyright. And then if you morphed that into, say, a white paper version of the content, that can be protectable by copyright. Each of these versions, similar to, say, the original Romeo and Juliet story was written as a book. That book is copyright protectable. Then somebody screenplay or writes it for theater live production. The live production is a separate version in a fixed medium that can be copyright protected. And then nowadays in the digital era, somebody in the audience videotaped it. So that fixed medium of the videotape is a separate copyrightable version. So it will help you, though all those different mediums of how it was fixed as content, and you being the author, original author. That's the key, is to be the original author.
Okay. Thank you.
Yeah, good questions. All very practical what you're going to run into. Moving along, last slide on the navigating the patent process. So at the time of allowance, there's a good time to review strategy and some of your R&D and products. How I said the patent process lasts, several years. In the software world, those initial products are archaic. They're no longer on the shelf. We've turned them over, and next generation version 3, 4, 5 have happened. So the allowed claims of the patent application, is that covering my current products or even my next generation products that are about to launch in the next 6 months? So the strategy step is to, at that time, look at your patent application, the allowed case, and possibly think of using that as a parent patent application and spawn some children patent applications. So you can let the parent application, you eventually will let that one grant as a patent, and just ahead of the grant date, file these child continuation type of applications. And that will keep the original filing date as your effective earliest filing date, which is the benchmark for what the examiner needs to measure backwards in time to find prior art in order to see how novel your invention is over all the rest of the world as of that effective filing date. So that's a good strategy, to be able to hang on to that earliest effective filing date by filing these child continuation applications that inherit the benefit of that parent filing date. Meanwhile, your first case did grant, and it's a thriving patent, but you have ongoing continuation applications pending at the patent office. That can help also with some of the post-grant challenges that your parent case might run into. And in those challenges, a potential competitor might want to try to invalidate that patent. And even if they're successful, you have that pending continuation application that in its own right could develop into a separate granted patent. So that's the strategy just about ahead of the time of grant of a patent, a first patent in a family of patents. Think of how you want that family to develop into those ongoing continuation applications. Again, if you're budgeted and have the, I guess, the time and money kind of budgeted for that. And that brings us to the last step on the punch list. What are the uses of a granted patent? And think of patents as well as patent applications are assets of a company, and you can capitalize on this asset. You can license or sell outright your patent rights. You can attract investment with the granted patent or a whole portfolio. I said that you have your granted patent and some in the wings pending child applications, and that will show some strength behind the engineering concept that's trying to be patented there. And certainly enforcement is a use of a granted patent. You would want to be properly prepared for that possibility. A couple of preparation steps are to mark your products that are covered by that patent. At the patent application stage, we were marking it as patent pending. Once the granted patent has been issued, there will be a grant number, the patent number that you want to mark on your products, or at least the materials, user guides, any of that literature that goes along with the product or the packaging. An easier way now under the American Invents Act, the AIA, is virtual marking, which says on your website you can have a web page that's freely accessible to the public that states your different patent numbers, granted numbers, and that those are the patents that cover your products, and helps to place on notice all of your competitors, all of the consumers, that there is patent protection surrounding, again, those boundaries surrounding those products, and they should beware. And if you're serious after the preparatory steps, then you see an infringer, cease and desist letter. If you're trying to counterbalance that with license and as opposed to being adverse, trying to be more friendly approach to it, a royalty stream from a license agreement isn't a bad thing. Some of the timing considerations, there's statutes of limitations for taking an infringement suit, and there's certainly the burdens and risks. There's pluses and minuses of trying to use the court system. Again, another long process you need to be properly budgeted for, and a patent litigator as opposed to a prosecutor to help you strategize there from day one. Even the proper writing of the words that go into a cease and desist letter to help you position yourself for proper jurisdiction, location, certain courts with judges that your patent litigator is familiar with is better than in a jurisdiction where your competitor is stronger in, and you have a disadvantage and need to have local counsel acquired. So all of these kinds of considerations go into that enforcement play. So in a nutshell, that's our punch list, and I have a final exercise that I think might focus what we've learned and covered today. These are a series of questions that I think if you have a unique something, a specific technique, other formulation, for this exercise I'm going to just call it your unique twist, and that's going to give you that competitive edge in your market space. What are the ways that you can protect that unique twist, and what you should think of mixing and matching patents, copyrights, trademarks, trade secrets to the extent available. And that's what this series of questions hopefully can help you give a thumbnail sketch to. So for your unique twist, ask, is it playing the role of identifying you in commerce as the source? If you're answering yes, that's the primary role of this unique twist, then that's really screaming trademark. You want to try using trademark to protect that. If you answered no, then go on to this next question. Is your unique twist never exposed to the public and would be very difficult to reverse engineer? If you answer yes, then that tips the scale closer toward trade secret and then other protection. If you answer no, then the next question you want to ask is your unique twist exposed to the public but not worth the time to reverse engineer? It's most likely more fruitful for some player out there to pirate that unique twist. If you answer yes to this question, then that tips the scale closer towards copyrights than these other areas of protection. And if you answer no, then it's not a matter of pirating or any level of difficulty in the reverse engineering, but the fundamental innovative concept has a value proposition. If you answer yes, then that's really more at the heart of patent protection. So a summary question that I like to counsel clients with their first time through this whole, it just by this time their eyes are glazed over, they're thinking, wow, that's a lot to absorb here. So I usually end the question with, would you be upset if a legitimate customer purchased your product, but then went into his garage and reverse engineered it, and from that reverse engineering started to compete against you in the market? If that would make you upset, then it tips the scale toward patents. Okay?
Great.
So I hope these were practical, good exercises that you can apply as you go along.
Well, I have one more kind of out of left field question. Do you have any pet peeves about your clients? What can you do to be a great client of an attorney so that you've got a really efficient working relationship?
I think a couple of pet peeves. One is where I feel that I've given some good tips, some practical self-help, but the client still didn't listen. They went off and did the opposite of what I said, and then they come back and want it fixed.
Mm-hmm.
So I think the lesson is to listen slowly and well, and if you truly aren't digesting that and interpreting it clearly, maybe the eardrum did receive the sound wave, but the actual interpretation didn't sink in. So ask questions. I think that's my other pet peeve, is that I feel sometimes it didn't rise to a question level in our session, but they didn't, after that session, come back with an email, a phone call saying, hey, you know what? I've been thinking about what you said, and step one and step two aren't quite making sense again to me. Could you, can you re-explain? So I think that's a pet peeve, when they don't ask the question and went off and chose the opposite of what I thought I advised,
Yeah.
and then they come back and say, it's not working.
Okay.
But certainly organization and documentation, that will go a long way, because it is sometimes hard to remember or hard to pull that out right in a dialogue meeting with your attorney. So if you come prepared, have your documentation and ongoing documentation, that will go a long way.
So if you hire me, be sure to have a gun or something to hold to my head to make sure that I document any inventions. But the main thing is that one of my favorite sayings that I use all the time when I'm coaching on pitches is to remember that all attorneys cost the same in the end. You either pay up front for the services of a good one, or you pay in the long run to fix the mistakes of a mediocre one. Now, that said, we do have this free offer here from Mary Lou to speak with you for 20 to 30 minutes, and there is her contact information. I hope you've grabbed it, because I am going to take control back and just give you a little bit about what's coming up next. But first, I'm going to say, Mary Lou, thank you so much. That was an incredibly information-dense session. You stayed an extra 15 minutes. Super appreciate it. So thank you, thank you.
My pleasure. Thank you.
Pleasure is definitely mine. Okay, so oops, where is this? There we go. All right, so our next Ask a Pro, with the standard being held very high by our first 4 speakers, so thanks again. It's winning with SBIRs, funding your startup without dilution, which I know is a big factor for many of you. That's on Thursday, November 5th, 2 weeks from now. You can register as usual at bit.ly/about AAP for Ask a Pro -005, and spelling and even capitalization do count here. And for those of you who are mentees who've been accepted into the fall 2015 cohort, first of all, welcome. And I hope you'll be getting your introductions to your teams tomorrow. That's my plan. You can probably hear I've got a kind of a cold right now, so things have gone a little bit slow. Apologies for that. Anyway, we'll be taking your suggestions. Actually, I will be taking your suggestions for new webinars. So be sure to come with any ideas, any possible area of interest to you. I'm happy to find somebody who can come and give a practical discussion about it. Okay, and if you missed the previous Ask a Pros, they are on my YouTube channel at Ask a Pro-playlist. By all means, take a look. Today's What Not to Patent will be up, I hope, by probably noon tomorrow. Okay, and as I said, coming on up after winning with SBIRs with very experienced Natalie Rudolph, we have an interview with Gary McNamee, who has, like I think I said earlier, done a great job of bootstrapping his company, so that should be really fun. And then user interface design, especially as it pertains to websites. And as always, I wish you the very best of luck and success with your startup. Thank you so much for attending. My name is Linda Plano, and my company is Plano and Simple. I coach entrepreneurs on how to pitch to investors and customers, and it is my passion. So drop me a line, linda@planoandsimple.com, and don't forget to get in touch with Mary Lou and ask her your toughest IP questions. Thanks so much, everybody. Have a great rest of the week. Bye-bye.